You know, when you think about how a country's legal system gets made, you probably picture something, well, planned. You imagine experts huddled together, carefully crafting every single rule. But what if I told you that an entire nation's common law was born not from some grand design, but from a complete accident? From a promise that just couldn't be kept? Let's get into the incredible story of how Sri Lanka's legal foundation was built by mistake.
Okay, so imagine this. You've just taken over a new territory. Your official policy, the big promise you make to everyone, is that you're going to keep all the old laws in place. Simple, fair, sounds like a good plan, right? But there was one massive problem.
What on earth do you do when you can't actually find the laws you just promised to uphold? That was the exact head-scratching puzzle the British were facing in colonial Sri Lanka. And the way they solved it would accidentally shape the entire legal system of modern Sri Lanka.
So, our story really kicks off at the turn of the 19th century, right as power on the island is changing hands in a big way.
Now, this wasn't some overnight takeover. The British first grabbed the coastal provinces from the Dutch way back in 1796. It then took them all the way until 1815 to get control over the whole island. And with all this new land came a pretty fundamental question. How are we going to govern this place?
The British actually had a standard playbook for this kind of situation. Their policy wasn't to just storm in and slap English law on top of everything. No, the usual rule was to keep things running as they were, to maintain the laws and institutions that were already there. It's called legal continuity.
And they made this totally official. It wasn't just a suggestion, it was a formal pledge. The proclamation of 1799 clearly stated that justice would be served according to the laws that subsisted under the Dutch. A straightforward promise. So far so good, right? Well,
this is exactly where that nice, simple promise started to completely fall apart and turn into a huge headache for the new administration.
This was the million-dollar question. I mean, if you're going to enforce Dutch laws, you kind of need to know what they are first. And for the British, getting a straight answer turned out to be nearly impossible.
They just hit a brick wall at every turn. First off, nobody could figure out which Dutch laws were even supposed to apply to Ceylon. Then you had the former Dutch officials who were, let's just say, not very helpful. Their judges flat out refused to work in British courts, and to top it all off, it's pretty likely that a ton of important legal records were just destroyed. The rulebook wasn't just unclear, it was basically gone.
So what do? You have real people with real problems showing up in your courtroom every single day. Without a rulebook to guide them, the British judges had no choice but to get creative and, well, improvise.
You can see this improvisation play out in real cases, like this one. So there was this old Dutch law from 1674 that said if two people had an affair, they couldn't get married after the spouse died. But when a case like this came up in Ceylon, the court made a really bold call. They essentially said, look, we have no proof this specific Dutch law was ever formally brought to the island, so it just doesn't apply here. They were filtering out the laws, one case at a time.
To justify these kinds of decisions, the judges in Ceylon started using a fascinating legal tool, one that doesn't even exist in English law. It's called abrogation by disuse, and it's a really cool idea. It basically says that if a law is so old and hasn't been used in forever, it's effectively dead. It's void. This gave them the legal cover they needed to ignore old Dutch rules that just didn't fit.
and this practical way of thinking was laid out perfectly by Chief Justice Lascelles in another case. He basically argued, hey, if a Dutch law has never really been used here and it clashes with local customs, we can just assume it was either never introduced in the first place or it's been abrogated by disuse. The judges were literally shaping the law to fit the reality they saw in front of them.
All of this improvisation eventually led to a massive turning point. The courts started to realize that dicking around for specific, missing laws was a total dead end. They needed a new foundation, something more flexible to build on.
So they pivoted. The hunt for specific word-for-word Dutch statutes had failed. So instead of chasing the individual rules, they turned to the big-picture principles. They started applying what's known as Roman Dutch law, a much broader, more academic legal system based on Roman law but interpreted by Dutch scholars. It wasn't a list of rules, it was a framework of ideas, and that was something they could actually work with.
In what started as judges just trying to solve a problem on the fly eventually became official policy. The courts basically invented a solution out of thin air, and then the government came in and made it law. An ordinance from 1835 was even named the Adoption of Roman Dutch Law Ordinance, which pretty much sealed the deal.
And this whole chain of events, a promise, a huge problem, and a clever improvised solution, left behind a really profound and lasting legacy.
That system, the Roman Dutch law that judges turned to out of sheer necessity, became the common law of Sri Lanka. Think of it as the default legal system. Whenever other specific laws, like personal or customary laws, don't have an answer, Roman Dutch law is what fills in the gaps. So the big takeaway here is that Sri Lanka's unique legal system wasn't born from some master plan. Not at all. It was forged in the messy reality of a colonial handover, created because of a missing rulebook and the practical, on-the-ground wisdom of judges who just had to make things work.
And that leaves us with a pretty fascinating question, doesn't it? When we look at any legal system, anywhere in the world, how much of it is truly the result of careful, deliberate planning, and how much of it, like in Sri Lanka, is really the product of historical accidents, practical fixes, and just plain old human improvisation?